Good morning, everyone. Welcome to another edition of the WILMIC Annual Summer Seminar. Thank you for joining us today. We are coming to you from the State Bar Center on the far east side of Madison. I want to thank those who are in the room today in attendance in person, as well as all of you who are joining us online. We appreciate that very much. We have a 3-hour program for you today. We'll run from 9 to about 10:15 first with our first program dealing with the trust account e-banking rules. They underwent some changes as of July 1st, and the trust accounting rules are, at least in my view, are not easy to understand to begin with. And when we get changes like this, it's always good to run through them and try to understand exactly what is necessary so that you do not run afoul of those rules. And so Travis Stieren is here with us today. Travis will go through the whole list of changes and really kind of outline all the rules for us to figure out what it is we have that guides us to do that. Travis will go till about 10:15, as I said. We'll take a 15-minute break at that point, and then at 10:30 we will have Aviva Kaiser in. She is Ethics Counsel at the State Bar, and she will talk to us about artificial intelligence, AI, and ChatGPT. A very fascinating area, one that I think most of us, if not all of us, really do not have a great handle on yet as to how it can work and how it can be work to our advantage, as well as some of the risks and pitfalls that may be out there. So some good topics today, and again, thanks for joining us. On your screen, you should have not only the speakers, but also you can see the materials. There is a materials tab, and if you click on that tab, you will get the materials on your screen. If you have a question or a comment, there is a tab called Ask the Speaker. Click on that tab and you can write in your question or comment. We will get those electronically, and we will address those as they come in. So feel free to send those in at any time. You don't have to wait till the end of the presentation. Just jump right in and we will get to it. And of course, those of you in the audience here, all you have to do is raise your hand. So that should be real easy. So that's about it. We'll get started. E-banking, modernizing trust account rules. The rules changes effective July 1. Here to tell us all about it, Travis Stieren. Travis, thank you for being here today.
No problem, Tom. Thank you for having me. With the trust account rule, it reminds me of a joke that my 11-year-old told me. He says, there are three things, the three hardest things in life are to say are, I don't know how, I need help, and Worcestershire sauce. So, and basically, you know, that I always think of that when I think about our trust account rule, because the trust account rule in Wisconsin has been one of the most complicated and complex in the country, and we've been working, and we've been aware of that, and we've been working to simplify it and pretty much update it so that lawyers can manage their trust accounts easily and focus on, you know, their practice instead of worrying about the trust account rules. So what we've done is we filed a petition last year to update the trust account rule to allow much easier access to electronic banking and basically to no longer require paper checks for most transactions. So we're going to talk about that, you know, and so we're going to talk to you a little bit about, you know, here's what it is, and if you need help, please contact us. You know, we're trying to help people come into compliance with the rule and help them understand and handle the funds appropriately. OLR is not here to try and tag you on technical violations of the rule. We want to help you comply and help you to handle third-party funds, because what we're talking about here is when you have someone else's money, you're a fiduciary. You have to treat it as your own, if not better than your own, and you have to be able to fully account for all the funds you have. And if you do follow the trust account rule and our recommendations, you should be able to do that quite easily. So let's see here. There's a little bit about me. My email address is there and phone number, so if anyone needs to contact us, and you can also see our webpage. There's a link there. If you download, I think you'll be able to click through to the link. But otherwise, if you go to wicourts.gov, you can link through to the trust account page there. So in the early 2000s, I think it was in 2004 originally, the Supreme Court passed a rule essentially prohibiting electronic transactions in trust accounts. The fear was at that time the electronic transactions were not as reliable. There were reversals and chargebacks that couldn't be accounted for. There was no way to handle those. So the court, took the position that you basically had to have a checking account with paper checks, and you couldn't accept credit cards. You had to accept, either cash or checks or wire transfers, et cetera, from your clients. But they just didn't want any type of electronic transaction, like a credit card transaction, where the third party could challenge it and could reverse it without the attorney's knowledge, and therefore jeopardize other funds that would be on deposit in the trust account. So this is the definition of electronic transaction under the Supreme Court rule. So it's a paperless transfer of funds to or from a trust account or a fiduciary account. I should note that 1.15, the general trust account rule, also applies to what's known as fiduciary accounts under the trust account rule. And these, it's distinct from trust accounts. Trust accounts are when an attorney is holding funds in trust relating to a representation in which the lawyer is wearing the lawyer hat and they're actually representing a client. They accept funds and they hold those in trust. If the lawyer is wearing a different hat, if they're like a guardian, or if they are the personal representative of an estate or something of that nature, if they're a trustee, then under our rule, it's considered a fiduciary account. But by and large, the rules apply to both standard lawyer trust accounts and also these fiduciary accounts where the lawyer's acting in some other fiduciary capacity other than just as an attorney-client situation. So this is what electronic transaction means under the Supreme Court rules. And you can see we've published an article. It's available through the State Bar website and in the Wisconsin Lawyer Magazine. It was the State Bar Ethics Counsel and myself who put this together to kind of puts guidance on the new rule. So I think it's a pretty lengthy article, and it summarizes everything pretty well. So the 2016, after 2004, of course, the court very quickly started hearing that lawyers want to accept credit cards because basically they need to get paid. And usually in a lot of cases, the people don't have cash on hand in their checking account. So it was a big problem. So the court heard the complaints about not being able to accept electronic payments. And in 2007, they started allowing lawyers to accept credit cards if they had a second trust account. We called it a credit card trust account. It was just kind of a pass-through account just for receiving those electronic credit card payments from clients, and then they had to promptly transfer it over to their regular trust account. So it kind of insulated the regular trust account because you had to accept payments from one and then move it over to the second. And that worked it worked a little bit, but it still wasn't quite wasn't meeting the demands of everyone, because you couldn't take, ACH transactions, anything that wasn't credit cards. So in 2016, there was another revision of the rules, and this was to kind of broaden electronic transaction access. So what the court came up with then is, again, still there's a general prohibition on electronic transactions in lawyer trust accounts and fiduciary accounts. But what they did was they said you can make remote deposits electronically, because those are pretty safe. If you're making a deposit, it's not going to be reversed if it's the lawyer making it. So that they started allowing lawyers to make remote deposits if they had the little scanner machine in their office, or other ways of doing it remotely. And then they allowed lawyers to there are two different options for accepting electronic transactions. The first was the e-banking trust account, which was formerly the credit card trust account. So it was the same idea. You just had a separate account designed to accept credit card payments, ACH payments, any kind of electronic payment. You accepted those, and then within 3 days, you had to move the money over to your standard trust account to hold it in trust there. So that was what they came up with. The other option was to use your regular IOLTA, but you had to have significant additional security requirements. Most notably, you had to have a crime insurance policy or a bond attached to your trust account in the amount of the maximum daily balance from the prior year. So you had to have an insurance policy that would cover whatever was in your trust account effectively the year that you opened the insurance policy. So that could be a policy worth millions, and depending on your practice. So that was an expensive thing. There were not a lot of insurers who were writing this policy. OLR worked with the State Bar and an insurance company to put together a policy that would meet that crime insurance policy requirement. If you got that policy, or another insurer was willing to issue a policy or a bond, you could have electronic transactions in your regular standard IOLTA trust account. The problem was, like I said, it was hard to get those in policies. There was only one insurer, maybe a few others that worked on it as well. But the one insurer who was doing it, with the State Bar's kind of blessing, they announced about a year and a half ago that they were no longer writing the policy. It was just a product they weren't making money on. They decided to discontinue it. So effectively, lawyers couldn't really do the all-in-one trust account, even if they wanted to. So again, with the times changing, everyone wants to be able to use electronic transactions and get paid. So OLR filed a petition to change these. And again, here you see that the exceptions that they allowed were kind of difficult to follow, and they were burdensome, as I kind of touched on. And what we saw was that some lawyers were they're like, oh, this is too complex, it's too much of a pain, I'm just not even going to use a trust account at all. And they were going to use the alternative protection under 1.5G, which I'll touch on a little bit as we go through this. But essentially, the court created a new exception so you could avoid using your trust account entirely. Or, in the alternative, lawyers would just simply go ahead and accept electronic payments and risk getting caught because they needed to get paid.
Hey, Travis, yes, sir. Can I jump in for a second? Since that 2016 revision, we had received calls now and again from lawyers asking about was there software available, because many of them weren't sure how to, from an IT perspective, set this up to stay in compliance. Right. And so their question was, is there software available out there? Was there ever that, or were there programs that they could use?
Yes, there were several vendors who did kind of electronic payment processing and accounting, and the State Bar recommended LawPay. They're kind of one of the bigger ones, and that's available as one of the State Bar benefits. I think it's on their website and everything. LawPay is one, but there are several others who would manage, kind of a full suite of accounting for lawyers. And LawPay set it up so they got to know our rule, and they were able to set up the transfers between the bank accounts, between the e-banking trust account and the regular trust account. So they were one who took the time and adapted their software to the needs of the rule. But I don't think there were a lot of them.
Yeah. That was my impression too.
Yeah.
And I know you're going to get into the most recent changes. Do you think we're now at a point where it's become a little easier for lawyers to manage and to find the right program software to utilize this?
Yeah, I think so, especially with the new options that are available. It's essentially you can just use electronic transactions in your trust account just like you would in your own checking account. So and so that's pretty standard now in all these software suites. So you don't have to have all these extra hoops to jump through.
Yeah.
So.
Good.
Okay. So here's what we've kind of done, a little overview of what the new rule allows. We've done away with the general prohibition on electronic transactions. So electronic transactions are allowed in all trust accounts and fiduciary accounts so long as there are commercially reasonable security measures in place. And that's not a well-defined term because it's a moving target. As the banking industry changes and adapts, they're coming up with new ideas. But we're familiar with having a password. We're familiar with having two-factor identification. Well, they'll send you a code on your phone and you have to type that in. Those kinds of things that the banking industry is coming up with. Basically, lawyers need to stay abreast of those and have what's considered reasonable security measures under the current situation in the banking industry. You no longer have to have your second e-banking trust account. So if you have an e-banking trust account, you can keep it, but you no longer have to do the thing where you put electronic payment into one, wait for it to clear, and then move it over to the other. Essentially, you only need one trust account now. And we've created there's a new exception, and maybe I should back up a little bit. I was talking about this alternative protection for advanced fees, which kind of allowed people to work around having to have a trust account at all or use a trust account. And this is another thing that the bar, some members of the bar, primarily the criminal law bar, I think, and maybe also family, they basically said, look, we need to get paid up front or we're not getting paid, especially criminal law folks, right? So what the court did was they created an exception it's now under 1.5G. They call it the alternative protection. And what it says is, lawyers can take advanced fees and put them right into their business account. They don't even have to use their trust account. They can put them right in their business account. But there's a whole lot of extra security measures then because you're not putting them in trust. And what those security measures are, basically, there's notice provisions at the outset where you have to have written notices at the outset, like, look, to the client, look, here, I'm accepting this fee. I'm not putting it in a trust account. I'm putting it in another account, but I have to fully account for it to you. And if you're at the end of the representation, if you're due any refund, I have to provide you with a refund. And I have to tell you when the representation's over, and I have to provide you an accounting at that time. So you have to give these notice provisions, and the State Bar was great at creating some sample language that people could put right in their fee agreement for that purpose. But the big hook of it was at the end of the representation, the lawyer had to tell the client, look, you have a right to binding fee arbitration. This is how much my fee is. This is how much I've taken. This is how much of a refund you're entitled to. And if you're not unhappy with this, you have the right to request binding fee arbitration. And so the client was essentially given like 30 days to submit a claim to say, hey, no, I'm upset. Let's go to fee arbitration. And the lawyer had to enter into that. So that was what was kind of the concession by the attorneys who wanted to take these fees, is that, okay, we'll agree to binding fee arbitration. 1.5G, however, only applied to advanced fees. Any advanced cost advances still had to go directly into the trust account and held there. So what we've done now is we've added, we've added a new exception that allows lawyers to accept advanced fees directly to their operating account. Or a non-trust account, usually the operating account. Advanced fees and advanced cost, if they're paid by credit card, ACH transaction, some kind of electronic payment, can be deposited temporarily into your operating account. And then the advanced costs and fees must be moved into trust unless you're abiding by the alternative protection, in which case the advanced fees can just stay in your operating account. But the idea here is there's a lot of small and sole practitioners who the cost of having a credit card processor can be significant. And if you have one that's connected to your operating account and you're paying for one connected to your trust account, for a small practice, that can be a lot of money. And it's also a lot of upkeep and accounting. So the idea here is to say, okay, you can accept electronic payments straight to your operating account, so that way you only have to have one card processor agreement in place. So we're kind of giving you that, but you can accept your advanced fees and costs there, but you're only accepting them as a means of payment. The trust account rule, the duty to hold funds in trust, still normally applies. So if you're using your trust account, you have to promptly, within 2 days of receiving them, move them over to trust and hold them in trust. So it's kind of a little cost-saving measure. It gives lawyers, especially small practitioners, another option, and hopefully that it will save them some costs and make it easier for them to accept electronic payments. So that is a new thing that we've added. At this time, there are only 3 other states doing this so far, but we expect more will do so. And then, of course, since we're no longer have the prohibition on electronic payments, you're no longer required to have a crime insurance policy or bond in order to have electronic transactions in your primary trust account. Okay, so that's gone away. You can, and one of the kind of the big hassles with the trust account rule the way it was, if you have earned fees that are in your trust account, you just want to get paid, you had to cut a check from your trust account. So a lot of times we do it a bash at the end of the week or month or whatever it is. Lawyers would cut out a big check. Here's my earned fees, and then they take that and walk it over and deposit it into your trust or your operating account. But that's no longer required. You can make electronic transactions, transfers in between your trust account and your business account. So if you have earned fees, you can just go online, transfer them over. But of course, you do need to fully account for those. So you do need to make an entry into your trust account records that shows that I've moved my earned fees from in the Smith personal injury matter. I earned those and I moved them over, and you want to make a contemporaneous record of that, but you are able to electronically transfer funds in between your trust account and your other accounts. With respect to your e-banking trust accounts, if you have them, some firms have them all up and running, and they kind of like it because it's like they just know all the electronic payments go in here, and they're safe. There's no reversals, no chargebacks. They get the money in there, and then they move it over to their other trust account, the standard IOLTA trust account. You can continue to do so. The new rule doesn't require you to close any existing accounts or change what you're doing. It just gives you the option to start making electronic transactions in your trust account. So if you have an e-banking trust account and you like it, you can keep it. There it is. No affirmative changes that you have to make. So the idea, again, we're trying to give lawyers more flexibility and make it easier, not harder, for you to get paid and for you to manage your funds. Okay, so this is 1.15F, and I'm not going to read through it all, but this is the security of transactions portion of the rule, and it's similar to what it was before, but it's basically been updated to include electronic transfers. Every transaction needs to have commercially reasonable security measures in place, and the lawyer needs to make sure they're up to date with the bank, and every transaction needs to be authorized by a lawyer or someone under the lawyer's direct supervision. Let's see. So what we recommend here is that lawyers, create a contemporaneous record of any electronic transaction. The nice thing about checks is you get the check back, right? So you had a record of it with your monthly statement. Electronic transactions, there's going to be a note on your bank statement or other, your online portal, but you want to make sure you make a contemporaneous record of that. Oftentimes you can get, when you make an electronic transaction, there's a line with, I think it's up to 50 characters where you can enter what it's for, but you want to be able to identify what that payment is for if you can, enter in a client code or name or something so that you can identify and account for it later.
Travis, so if a lawyer is taking a payment for advanced fees,
correct,
does that have to go into a non-trust account first?
Well, advanced fees, it does not have to go into a non-trust account. For advanced fees, normally you would put that into your trust account until such time as it's earned. Yeah. So now under the rule, you should accept all advanced fees in trust, with the exception that you can accept electronic payments temporarily to a non-trust account. Should say electronic payments for advanced fees or advanced costs temporarily to a non-trust account, but you have to move them over and hold them in trust until they're earned.
So if it's an electronic payment, it doesn't have to go into the non-trust account first?
It does not.
Not necessarily. Okay.
No, that's just like I was saying, that's just that option. If you only have one credit card processor and it's attached to your operating account, it can go in the operating account just briefly until it's there, and you have to move it over and hold it in trust, because the duty to hold in trust persists.
Yeah, okay.
This is kind of continued on the security transactions. This was the big concern all along, is that there would be a reversal of whatever the payment made from client A, makes a reversal, and then you've already expended some of client A's money. So if there's a reversal, client B's funds could be cut into a little bit. So that was always the concern with electronic payments. So under the current rule and the previous rule as well, under the e-banking rule, you basically have an obligation to, the attorney has an obligation to make the trust account whole in the event of any chargeback, ACH reversal, any kind of, if there's a claim of a fraudulent payment or something and the funds go missing, it's the duty of the lawyer to put the funds back in. And they have to do it within, I believe it's 3 business days, and they have to do it prior to dispersing any other funds from the trust account. Okay, and it kind of makes sense. There's a problem in the trust account. You need to make it whole before you start cutting out checks to other people. Again, that's kind of the big issue there. And again, that the fiduciary duty persists throughout. So it is tough, but again, you're making the decision to accept a payment. If it doesn't work out, it's up to you to make it right. Okay, this is a little bit of an aside. Wire transfers are not specifically mentioned anywhere in the rule, but they are not a prohibited electronic transaction, and they have never been prohibited. Electronic or wire transfers have always been considered, good money, good funds, because they're dependable and they're reliable. What it is, it's a direct bank-to-bank transfer that goes through either the SWIFT system or the Fed wire system, and they've existed since the 1800s. But you get wiring funds from one bank to the other, and the thing is, they're non-reversible. Once a wire transfer goes through, nobody can reverse it. So there's no concern with that. So wire transfers have always been permitted, and they are still permitted. The only transactions that are not permitted now are cash transfers or cash withdrawals and telephone transfers, because there's no record of those. So the idea is that we want to be able to trace the transactions, trace the funds. Cash transactions, telephone transfers, there's no record of it. Oh, and the other thing one caution, and I'm sure everyone who's watching probably understands, the wire transfers, because they're non-reversible, you got to make sure you get it right the first time. You got to get the information correct, making sure it's going to the correct account, the account number. That's kind of the rub, is like you can't go back and challenge it later. Once the funds are through, it's through. And also, and this is kind of stepping back a little bit, but there's been a lot of fraud with respect to cashier's checks payable to attorneys. And this isn't directly on point, but I know this is something that insurers are concerned with, because this is happening. We see this 4 or 5 times a year, where the situation is essentially a lawyer gets paid, they get a new client that comes in. Usually there's some kind of contractual dispute. The client wants the attorney to collect from this third party, and promises, you'll get, like a 10% of whatever the amount is as a fee. It's usually in the hundreds of thousands of dollars for the disputed amount. So the lawyer gets like, $10,000 to $20,000 for doing relatively little work. But what happens is this new client comes in, and within a few weeks, suddenly the client and the opposing party have worked out their differences, and the other party sends a cashier's check to the lawyer, and the other party, one of the parties is in Canada or someplace abroad, so they're demanding a wire transfer, and the client wants the funds to go immediately. The lawyer deposits the cashier's check, and then they walk over and get a wire transfer, send it to this random third party, and then the cashier's check comes back as fraudulent, and the lawyer's left holding the bag because the wire transfer's already gone through. There's no funds in the trust account. A week or so later, the cashier's check comes back as fraudulent. So it's kind of just a cautionary tale, and this is one we're seeing quite often. But before you make a wire transfer, you want to make sure you have the funds in your trust account, because the cashier's checks, the fraudsters are getting really good at forging them. And I've talked to people in the banking industry, and that's one of the big concerns. And it's one of the reasons they're trying to move away from checks entirely, is because the fraudsters are getting really good at it. We recommend that lawyers, if they do get a new client who they don't know, obviously you want to do your due diligence, and you want to research the person, but also, if you can, get them in your office, or at least get them on the phone. Don't just do everything electronically, and see if you can get in touch with them and let them know, look, if I get a cashier's check from you, I have to deposit it. I'm going to wait for it to be available before I can cut out your wire transfer. No matter how desperate you are, I have to wait. That's my duty. And a lot of times that will scare them off if they know you're going to wait until the funds are there. But it's really hard to tell if these are fraudulent checks. But what you can do, you can talk to your bank, and even your bank where you're going to deposit the check. They may not be able to help you, but they can pick up the phone and call the issuing bank, the bank whose name is on the cashier's check, and they can call up U.S. Bank or whatever it is and say, talk to someone there and say, is this a real check? You give them the numbers and they can run it through their system and tell you right then if it's fraudulent or not. That's basically the only way, is to contact the issuing bank. So that's all kind of an aside, but if you do get, if you or one of your insured gets a check, like a cashier's check, they want to make sure they're really careful, especially if it's from someone they've not worked with before.
That's really good advice, Travis. I know today cybersecurity is not the topic, but it's a great point. I'm glad you raised it, because we've seen several social engineering, as they call them, wire transfer fraudulent claims, and of course lawyers have cybersecurity insurance as an option if they care to buy that and to protect themselves. But you're right, the best protection is taking the steps that you outlined there, because it can happen so quickly, and it can happen to lawyers who are even thinking that they're being really diligent. Wire transfers scare me a little bit because of all the fraud that's out there.
Okay, so moving back to the issue at hand. This is the new exception that I was mentioning. It's under 1.15B6, and this is the thing. There's two parts to it. Essentially, I talked a little bit about the alternative protection under 1.5G. That's been in the rule going back to 2016. Before that, it was in a different part of the rule. It was actually in 1.15 going back to 2007, but that's the alternative protection where you can accept advance fees and hold them in a non-trust account so long as you agree to binding fee arbitration. So now we've actually put language in the rules that highlights that point. It's basically an exception to the trust account obligation. So that is in there. And then the other part of this is the new exception that I was discussing, the one that says, hey, you can accept electronic payments directly to a non-trust account so long as you promptly move it over to your trust account once it's available and within 2 days. If there's any reason to think that you're not going to have the funds, you shouldn't be accepting the payment. So that's that new exception I've been kind of talking about. And the comment to it, there's comments going along with these new rules, but it essentially explains again that this is just limited short-term commingling. The general rule is you can't commingle client funds with your own funds, right? You have to hold the funds in trust, but this just allows, as a means of accepting payment, allows you to accept these electronic payments and then promptly transfer it over. So. Okay, and this is I've talked a little bit about this advanced fee alternative. The 1.5G alternative applies only to advanced legal fees. It doesn't apply to advanced costs. So advanced costs always have to go into your trust account, whether directly or whether by accepting them electronically and then moving them over and within 2 days. There we go. Cost advances. Again, this is exception 1.15 sub B sub 6B. It's just a means of accepting payment. It's not for holding funds. The funds still have to be held in trust. Okay, so we're going to look at this. These are some option charts. And Aviva Kaiser, who's going to be presenting to you in the next segment, she actually put these together. She did a great job. We worked kind of hand in hand on kind of putting the petition together and working this out, and she did a great job of visualizing it all. So this is what the electronic banking options looked like prior to July 1st, 2023. You see the general rule is that you couldn't accept any kind of electronic payments unless one of these kind of 3 exceptions applied, or you could do any electronic transactions, I should say. The first one allowed lawyers to make remote deposits. Okay, deposits are more reliable, and if the lawyer in the bank has set up a means to do so, they can accept remote deposits. The second one was the e-banking trust account, and then the third one was the alternative to the e-banking trust account, which we call the all-in-one trust account. That's the one with the crime insurance policy. And so what happened, effective July 1st, it's kind of been changed. Now, under 1.15 sub F sub 1, that's the, that's the security section there. Basically says electronic transactions are allowed so long as the lawyer has all the supervision, has the security in place. And also, there's the B6 exception, which I've talked about kind of at length. That's the one that allows you to accept electronic payments to a non-trust account and then move them over to your trust account. The prohibited transactions still remain cash and telephone. Those are things that lawyers should not be doing. With respect to the options, I'm going to discuss this already, but these are the kind of three different things. The first column you see traditional IOLTA trust account and a business account. If you have a trust account in Wisconsin, and this is still true under the rule, this trust account rule requires you to also have a business account or operating account. Because again, you have to separate your own funds from the client's funds. So the rule makes that effective by saying if you have a trust account, you also have to have a dedicated operating account or business account. So that was kind of the standard situation which most lawyers have. And then in addition to that, you could have a business account plus an IOLTA plus an e-banking trust account. That's kind of the middle column. And the third option was basically you have your standard trust account, but it's that all-in-one trust account where you have the crime insurance policy plus the business account. So those were kind of that's the whole universe of trust account options prior to July 1st. And this kind of just shows you what we've done away with. Basically, we've done away, you don't have to have the e-banking trust account, and you can accept electronic payments now. We've kind of erased those from the prohibited thing. So effectively, you're all in one, and the standard traditional IOLTA are the same kind of thing now. And this is a real nice one to take a look at. Well, the next one will be better because you can see how complicated it was for attorneys to try and navigate all these different rules prior to July 1st. If you had fees, you had to deal with the earned fees, advance fees issue, and then figure out where it was going to go as far as electronic payment to the e-banking or so forth. So it was kind of a complicated situation. But we think it's a lot more simple now. Basically, you can accept electronic payments if they're advance fees. If they're earned, they just go right to your business account. If they're advanced, they either go to your trust account, or if you're doing the alternative, you can hold them in your business account. With respect to costs, if they're incurred costs, kind of like earned fees, they go right to you. They can go right to your business account. If they're advance costs, they have to be held in trust. You can accept that briefly into the operating account and move them over, but advance costs always need to be held in trust. So that's what it's a little bit cleaner, a little bit easier to navigate for lawyers, we hope. Okay, and this is check, cash, or wire transfer. This really hasn't changed, except for we don't have the e-banking trust account situation at all in there. So it's pretty similar. Wire transfers for earned fees or incurred costs go right to your business account. If they're advanced fees, they either go to your business account if you're doing the exception with the alternative protection, or if not, they go into your trust account, and all advanced costs have to go in the trust account. Okay, I'm going to run through some examples now, and these are all pretty straightforward, but this is some examples of how you'd accept payment either electronically or by cash or check or wire transfer, and then how it looks if you're doing just the regular thing or if you're doing the alternative protection. All right, so here's example A. A client pays $2,000. There's a $1,500 flat fee and $500 in advance costs. The lawyer's not using the alternative protection for advance fees. So because they're not using the alternative protection, advance fees and costs must go into trust. Now, I want to note here, this is a flat fee. It's still an advanced fee. Flat fees have to be held in trust until they're earned. This is a mistake that a lot of lawyers will make, but until you do the thing that you said you're going to do for the client, they have to be held in trust. You can put kind of mile markers or goalposts, and say, I will you're going to pay me $1,500. If I do the initial appearance, I will have earned $500. That's a third of my fee there. If I represent you through trial, that will be the remaining $1,000, although that would never happen. But you can work it out so that you segment your flat fee, but you still have to earn it. You can either break it down or just have to. If you don't break it down, you have to justify that you've earned the whole fee before you withdraw it. So flat fees need to be held in trust, and as well as advance costs. So they're not using the electronic or the alternative. So prior to July 1st, you could be deposited in your all-in-one or e-banking trust account, and then transfer it over because this is an electronic payment. Effective now, you can either deposit it temporarily into your business account, and if it's an electronic payment, transfer it over, or you can just deposit directly into your trust account. So it's much easier to accept electronic payments now. Okay, let's see. And again, I've kind of touched on this at length, but I've kind of been repetitive because I want lawyers to get to know this part of it, is that, the general rule is you got to hold the funds in trust. We're making a little exception here just because of the cost of accepting electronic payments, that those payment processing services, there's a fee involved, regular fees and fees per transaction as well. So because of those costs, to help minimize that, we're allowing you to accept electronic payments to your trust or to your non-trust account temporarily, but the duty to move them over to the trust account and hold them in trust still remains. Okay, example B. Now we have someone who's using this alternative protection. This is where they are holding advance fees in their operating account, and they are subjecting themselves to the extra security, most notably, again, that binding fee arbitration. Under the rules, prior to July 1st, you'd have to put it into your e-banking trust account and then transfer it to the standard IOLTA, the entire amount. And I should make notes here because this is a combined payment. It has advanced fees and advanced costs. But even if you're using the exception, if it's a combined payment, because there's advanced costs in there, it would have to go right into your trust account, and then the advanced fee portion would be moved over to your operating account or another account. So that's how that would look before July 1st. Oops, let's see. And then effective July 1st, the entire deposit may be put right into the trust account, and then you can move the advanced fees over. Or if you're accepting electronic payment, like we said, we can put that all right into your operating account and then transfer the advanced cost portion over to your trust account within 2 days. So you can do it either way, depending on where you're accepting electronic payments. At the end of the day, the advanced fees, if you're doing this alternative, should go into your operating account, and the advanced costs still need to go into your trust account. Okay, here we go. Now we're going to move over to, this is just to kind of review what a non-electronic payment looks like. Again, there's $2,000, and the clients say they're paying by check. The lawyer's not using the alternative protection, so we have advanced fees and costs. So prior to July 1st, you had to put all that in the trust account.
Hey, Travis, we have a couple of questions. A couple of questions from viewers. One question is, did you say you cannot accept cash and then deposit it into a trust account?
That's not correct. You can always accept cash. You cannot make cash withdrawals from a trust account. So you can accept a cash payment. Sometimes that happens. The client will come in, have a stack, and you may put it in the safe for the weekend and then deposit it on Monday. But yes, you can accept cash payments. Okay.
Another question from another viewer: can credit card processing fees be added as advanced costs?
We're going to touch on processing fees, but they're not part of. Well, what happens is, yeah, if you want to determine them as to be part of a cost, yes. But I'm going to touch on this a little bit. But essentially, if you're going to charge the client make them responsible for any of the advanced fees, you have to set that out in writing as part of your fee agreement. Essentially, it's part of the terms of your fees is that you're going to either make them responsible for the 3% fee or whatever it is. But just like anything else, it has to be reasonable and the client has to consent to it. So we consider that to be part of the written fee agreement.
Okay, and then another question from another viewer. If your engagement letter quotes a flat fee for estate planning documents with 50% earned upon signing the engagement letter and submitting the check, and asks for the 50% as a non-refundable deposit, is that consistent with what you mentioned as flat fees? And you can list portions that are earned upon certain events in the case.
Right.
Let's see how she wrote this. Earned after initial appearance. I'm not sure what she meant by that, but
okay, that's a good question. I'm glad it came up. Essentially, no, you can't do that. And I'll get into why, but there's no such thing as a non-refundable fee in Wisconsin. Lawyers have always, had this thing where they accept, they say that upon signing this agreement, I've earned, 50% in the case of this question, or some other portion of the fee, or even the entire fee. It's earned upon receipt. This is mine. No, don't do that. And if you have any insured people, if you're insureds who do that, they should not be doing it. Under Wisconsin's fee rule, it's 1.5 A and B, or what you want to look at. It makes clear that all fees must be reasonable. And reasonable means to earn it, you have to actually earn it. You can't accept a payment and then tomorrow terminate the relationship and say, well, I put non-refundable on the piece of paper, so it's non-refundable. No, the court is always going to look at reasonability, and you're always going to be required to refund any unearned fees. And earned means it has to be, you have to actually do work that justifies, a reasonable amount of fee based on the practice, the area of practice, the locality, and so forth. There's a number of factors to determine whether a fee is reasonable, but no, you cannot have a non-refundable portion of your fee. Even if it's a flat fee, it still must be earned by doing work.
Okay.
Okay, so getting back to this, in this case, they're paying by check, cash, or wire transfer. Nothing's changed. Okay, it's got to go right to the IOLTA account first until the things are earned or the costs are incurred. And here's my little note here. The temporary business account thing only applies to electronic payments. Okay, in this situation, we've got another advance fees and costs paid by, say, a check this time, and they're using the alternative protection. So prior to 2001, it all had to go into, it's a combination of advance fees and costs, so therefore it had to go into the trust account, and then you moved the advance fees over to the non-trust account. Effective July 1st, it has to all go into the trust account, and then the advance fees must be transferred. And in this case, before you had to issue a check from your trust account to your business account for that fee portion, but now you can either issue a check out or transfer those by electronic transaction. So that makes that a little bit easier to do. The lawyers got tired of cutting these checks all the time, so this way you don't have to do that. And this is coming back to that question you raised earlier, fees and surcharges on legal fees and costs. Okay. I'm not going to get into the weeds on this, hopefully, too much, but just due to some drafting differences in different portions of the rule, the wording resulted in the fact that effectively, prior to July 1st, if you're doing the e-banking trust account thing, you could not charge the client for surcharges or fees associated with the electronic transaction. If you're doing the all-in-one trust account, however, or if it was earned fees to your business account, you could charge the client for fees and costs related to the electronic transaction itself. So it was just kind of an oddity, and that was another thing we needed to correct. But again, essentially, if you're going to pass on these fees to the clients prior to 2023, you could do it, but you had to make the client aware of it. And it's kind of the similar situation now. Effective now, there's a comment to 1.15F1 talks about this, about the fact that there are surcharges and fees. We're all familiar with the 3% fee, right? Or whatever it is. If you want to make the client responsible for that, you need to communicate to that with them at the outset. And I suggest doing it, in the fee agreement itself. If we add 3%, for any electronic credit card payment or something like that, where it's clear to them and they've got written consent for it. That's the other thing is you do want to look, the lawyer's going to want to look at their credit card processing agreement and make sure that they can do that, because some of the agreements don't allow you to pass on fees, to third parties. So that's something you want to take a look at and make sure it complies with that as well as any other applicable laws. Supreme Court rule is only Supreme Court rule. There's a lot of other laws out there, as lawyers are well aware. So it's allowed under our rule, but you want to make sure it's allowed under your contractual agreements and any other laws. But if you're going to make your client responsible for it, it has to be in writing. And it could be that, you just bake it into the cake. You raise your hourly rate by, $25 an hour, or whatever it is, probably not that much, $1 an hour, something, just to handle all of the electronic payment fees you're going to have. But that's up to you. If you want to, bake it into the cake and make it part of your, just this is what my fee is, or say we're going to add on this 3% fee. It's up to you, but you do need to communicate that to the clients. My personal feeling is I don't like it when I go into a restaurant and they tell me they're going to add 3% if I pay by credit card. I'd rather they just put it in the price, and absorb it that way. But it's a business decision that lawyers have to make. Okay. So here's some common things that happened prior to 2001. Using your business account as a pass-through account to process electronic payments. This is the thing I talked about. Some lawyers they just weren't following the trust account rules. They're like, I need to get paid. They take a credit card payment and accept it to their business account. And some of them would move the money over and hold them in trust, but they weren't supposed to be doing that. And then the thing with depositing, if they're doing the alternative protection, some of them were depositing it into their business account and either not moving it over or just not recognizing it needed to be held in trust. And then some lawyers were just, if they had earned fees, I need to get paid, they would just transfer their funds from their trust account to the operating account. They're not realizing they weren't supposed to do that. So those are common things that weren't allowed that we would see a lot. But now, you can use that business account as a pass-through account for credit card payments, as we've discussed. Again, it's only advanced legal fees, not costs. And again, lawyers now get to transfer funds between their trust account and any other account that they have. And the same is true for fiduciary accounts. I should note that there was the rule on fiduciary accounts is a little bit different. I mean, it's within 1.15, but it's 1.15 sub K deals with fiduciary accounts and how they work. And it was by and large similar to regular trust accounts. But with fiduciary accounts, again, that's where the lawyer's not wearing their lawyer hat. They're, a personal representative or guardian or something else. Under those, there was more flexibility because it's just one fiduciary rather than a pooled client account. You're just dealing with the one fiduciary. So there was, it's a little bit less risk. So there were more electronic transactions allowed, but credit card payments were not allowed under the old rule prior to 2023. But now under the new rule, we've changed that so the fiduciary account mirrors what goes on the trust account. That is, you can accept electronic payments generally to and from, regardless of credit card, ACH, whatever it may be. Okay, so caution on taxes. This is, again, like I mentioned before, the Supreme Court rules are just the Supreme Court rules. I get phone calls from people calling me up, do I have to issue a 1099 for this payment or things like that? And my answer is I don't know. I'm not a tax guy. OLR has no authority in that area, and the State Bar doesn't either. They may be able to give some advice on what to do or where to go to talk to someone, but lawyers need to consult a tax professional. If you're going to be accepting electronic payments, there are some issues we've become aware of. The credit card processors, as you can see here, do require 1099-K to be created, and it doesn't. And sometimes this can screw up, I think, at the end of the year. Like you get an advance payment at the end of the year, you put it in your trust account, you got to issue a 1099-K, but it may not be earned until the next year. So you don't actually see that income until you've earned it and withdrawn it the next year, but it's still counted under the IRS as being received in 2022. So you have to issue the 1099 at that time. So you have to think about that issue. So therefore, the amounts that's reported on the 1099K will not really reflect the attorney's gross income at that time. So that's something to think about. And the other one is this issue with the EIN number that's attached to the bank account. If you're accepting credit card payments to a bank account, the EIN number on the bank account, as I understand it, has to match the name on the bank, the EIN number, the name on the EIN that's registered with the federal government has to match exactly the name that's on the bank account itself, the title of the bank account. And if it's not, there's a penalty that they impose. So you want to make sure you're taking note of that, look up that section, and talk to a tax professional and make sure you're doing that right, because again, we're aware of it, but we don't operate in that sphere whatsoever. So there you see, basically talk to a tax person. I know that lawyers are already doing that, but these are issues that are specific to electronic payments. And if you haven't been accepting electronic payments, you want to get up to speed on this stuff. Okay. So that's kind of all I have right now. There are some other, that's all I have on electronic payments. There are a few other rule changes that I've got here, but if there's some more questions, I'm happy to take those now.
Not at the moment, but okay. Yeah, why don't you dive into that?
As you see, the main thrust of our petition in the court's order was to modify all these electronic banking rules. But there's some other ones that that we needed some house cleaning, basically. And the first one actually deals with flat fees, which I talked about a little bit earlier. Under the definition section, 20:1.0 sub DM, D as in dog, M as in Michael, basically it deals with flat fees and what is the definition of a flat fee and when a lawyer can withdraw a flat fee. But it's amended to include the following language that reflects that all flat fees, indeed, must be earned prior by the provision of legal services before the lawyer may disperse them to him or herself. What happened was the definition of flat fees, there was some language inserted saying, and this was, again, due to the requests of some members of a significant number of bar members, that they're concerned that there was some kind of clawback either through bankruptcy or some other issue where that if an attorney accepted a flat fee, then later, like the bankruptcy court or someone else could come and pull that out. So there is some language inserted into the definition that said flat fee becomes the property of a lawyer upon receipt. And the purpose of that was just to show that the lawyer had some property interest in it. It wasn't just the client's money anymore. But a lot of lawyers have, interpreted that to mean, hey, it says it's my property upon receipt. Well, no, you have a property interest in it for purposes of hoping that someone will not come and claw the money out of the trust account. But what the rule says now is, notwithstanding that all lawyers have a property interest upon receipt of flat fees, such fees can be earned only by the provision of legal services. So that's kind of what I was saying before. You have to earn flat fees, before you can withdraw them. So now the rule is more clear on that point, and that was something that the we at OLR and the State Bar Ethics Council, I know that they've dealt with that issue a lot. So we wanted to be sure that was in the rule. Under 1.5G, 1.5 again is the fee rule. This was revised to clarify that advance costs must always be held in the trust account, even if they're accepted in the business account by electronic transaction. Again, advance costs, basically the words say, cost advances must be held in the lawyer's trust account pursuant to SCR 20:1.15 sub B sub 1 and 20:1.15 sub B sub 6. So again, that's just clarifying that even if you're using the alternative for advance fees under 1.5G, costs themselves, advance costs, always have to go into the trust account. There's a few more of these. Another one is that it's an issue that we thought was self-evident under the rule. 20:1.15 sub B sub 1 is the general trust account rule. That's the one that basically says attorneys must hold funds in trust funds relating to a representation in trust separate from the client's own money until such time, yada, yada. But essentially, there's no commingling. You have to hold client funds in trust separate from the lawyer's own funds until such time as they're earned and you move them out. But what we were seeing, and this is one I know this ethics counsel Tim Pierce this was an issue that he was wanted to be sure we included in the rule, was that there's no parking money in the trust account. A lot of times you get people like, well, I'm going to be doing this thing, I got a family inheritance, can I just put it in my own personal family inheritance? We got to split it up between my brothers and all this, and the lawyer's not the lawyer in the case. He just wants to park some money in there, or his brother asked him to hold some real estate proceeds in there because he's going through a divorce and whatever else it is. You can't put any funds in the trust account unless they are related to a client representation. Okay, you can't park just random money in your trust account, whether they belong to you or some other third party. The trust account rule is clear. And we've added language now. It says, except as provided by subsection B3, which I'll get into in a minute, a lawyer shall not hold any funds in a trust account that are unrelated to a representation. Okay, so anything that's in your trust account has to be related to a client representation. The only exception, which is subsection B sub 3, is that the lawyer may hold a nominal amount of funds to cover bank fees. Okay, we call it the maintenance account funds. Essentially, it's usually about $100. You can keep some money in there to cover bank monthly fees, check printing charges, that kind of stuff. And some lawyers some big practices have a lot of bank fees if they're doing collections work or something. They can end up with a lot of fees. So if you know you're going to have a lot of bank fees, you can hold more than $100. But it's basically a nominal amount sufficient to handle bank fees and charges. Other than that amount of money, everything else in your trust account should be a client or client-related funds. So that is now explicitly in the rule, which it was not before. The next one is multi-jurisdictional practice. What happens is if there's a lawyer who's, say, he's Wisconsin, admitted to practice in Wisconsin and in Illinois, they're working in Illinois at a Chicago firm, the bulk of their practice is doing, work in Illinois, but they handle, some of the cross-border stuff, a few cases a year or what have you. The rule has always allowed that, not always, but for the last 15 or 20 years, has allowed that lawyer who's in Chicago at that firm to use their Illinois trust account for Wisconsin matters, so long as the bulk of their practice, basically more than half their practice is in Illinois, they can use their Illinois trust account for Wisconsin matters, so long as the Illinois trust account complies and they're complying with all the Illinois trust account rules. Okay, so you can do that, and that's explicitly put into the comment under 1.15 sub J. It says, this rule does not prohibit a lawyer whose principal office is in another jurisdiction and who permissibly represents clients in Wisconsin matters from using a trust account for Wisconsin matters that is compliant with the rules of the other jurisdiction. So you can do that. We see a lot of cross-border, Minnesota, Wisconsin, that kind of stuff. You can use if you're licensed in both, you can use your Minnesota one if you're primarily a Minnesota attorney.
How about the reverse, Travis? You're in Wisconsin and you take on some Illinois cases because you're licensed there as well.
Right.
Can you use your Wisconsin trust account?
Yes. Okay. The Illinois rule allows it. Nearly every state rule, as far as I know, and I know Illinois does. Okay. Yeah. So yes, that's a good question. Thank you. And the last one I kind of want to touch on is the fiduciary account rule. And I think I mentioned this one already, but it's 1.15 sub K. Is revised by way of deleting the prohibition on credit card transactions. And I think I did mention that all electronic transactions are allowed in your fiduciary account just like they are in trust accounts. So that's along with the trust account, electronic transaction stuff, those were the only other changes to the Supreme Court rules that are effective on July 1st.
Travis, how do you police this stuff? I mean, it's, lawyers are out there trying to comply. Do you get many disciplinary cases that deal with trust accounting?
We do. Well, there's a couple of things that we get. you're probably aware all trust accounts in Wisconsin, the lawyers require, for every trust account, the lawyers required, they call it an overdraft, to fill out what we call an overdraft notification agreement, and that's required by the rule. Basically, the lawyer and the financial institution, if the lawyer's going to have a trust account there, they have to fill out an agreement, and the bank has to sign it, and they provide it to us, essentially saying if there's an overdraft at any time, for whatever reason on this trust account, the bank will send OLR an overdraft notification notice the same as they would send it to you. So like whenever, if it's ever happened to you, you've got an overdraft, they send you like a one-page thing in the mail, they send the same thing to us. So we get the letter, it says it's overdrawn, and what happens is that kind of kicks off an investigation of what happened to the overdraft. And we send out basically a standard letter to the bank and to the lawyer asking for an explanation and any documentation that supports, why did this get overdrawn, and how did you handle it. 95 times out of 100, we handle those pretty quickly. They're usually just, I didn't have any money in my trust account, and I got a bank printing, check printing charge when I open the trust account right away. And now I've got an overdraft the first week I open it. That happens a lot. Or someone just grabs the wrong checkbook, issues it out of the trust account. It should have been out of the operating account. Those kind of things. Human errors happen. So those kind of things, we'll look at those. We have to look at those. If we look at the bank statement, the documents kind of supports, okay, there's just an error. They put the funds back in as soon as they learn about it. Those kind of things we don't seek discipline on. We'll send out a letter of advice saying, oh, here's what you need to do and modify your practice. Put $100 in your trust account as a maintenance account, and this won't happen. That, and I will note while I'm on that point is when you do open a trust, or the lawyer does open a trust account, and they say, hey, if you are still getting paper checks, they say, hey, charge my operating account for any bank fees, including the printing charges. And the bank will say, yeah, we'll do that. But what happens is the banker may tell you that, but a lot of times their automated systems will just charge the fee against the account number. And so there's automatically an overdraft sometimes. So we see that fairly often. Other than the overdrafts, we get some of these fraud things reported to us. That kind of fraud situation, which I explained earlier, lawyers will like, oh my gosh, what happened? What do I do? And they'll call us up and we'll kind of walk them through it. And those kind of fraud situations, it depends on what happens, but typically if the lawyer is otherwise complying with the trust account rules and they work with the bank to get the funds back, we don't seek discipline as long as there's not any kind of gross negligence or the lawyer wasn't involved or something. And then the third kind of thing we see is just coming up in the we don't do any kind of random audits. We don't look at trust account stuff generally unless we get an overdraft or unless trust account issues come up in the context of an actual grievance or another OLR investigation. Sometimes, there are money issues. A lot of times clients are mad about their fees, surprisingly. So a lot of times we will ask for the fee agreement, we'll ask for bank statements and so forth just to see that you did hold the funds in trust and that you did refund the unearned portion of your advance fee or whatever it is. But a lot of times that's how we find out about trust account problems, is in the context of another investigation on other issues. But we don't do any kind of random audit type things.
Right. Yeah. Okay. And do you have a sense for how Wisconsin compares to other states in terms of, the complexity of this stuff? Are we kind of in the mainstream or a little more difficult than others?
Especially before July 1st, we were, I think it's fair to say, it's us, and we were the longest trust account rule in the country. I looked at all of them. The model rule, just so you all know, the model rule, it is 1.15 under the American Bar Association model rules. It's 5 paragraphs long, and it's about we can print it on one page. Most of the states have added, 4 or 5 extra paragraphs having to do with overdraft notification. There's the IOLTA program and other, common things that most states have. Some of them, are 3 or 4 or 5 pages. Ours printed out was like 22 pages. So ours was, and there's only a handful of others that were more than 10 pages. So ours was, and it's well kind of known that ours was the most difficult trust account rule. So we've cut significantly back on that, and that was, we were looking at kind of a larger, full-scale revision of the rule, but we realized that the electronic banking was such a pressing issue. People we wanted to step into the 21st century, which we've finally done. So that was, our focus was just to really focus on the electronic banking, make sure lawyers could get paid. But while we did it, it did significantly shorten and simplify the rule. We think it's a lot easier to follow now.
Yeah, well, that's good. That's probably not a contest you want to win.
No.
Longest rule. Yeah. Okay, well, good. And I guess before we conclude here, again, the website that they can, on OLR's site, I think you have a link.
Yeah, it's wicourts.gov, and I have the full thing for us. But if you go to that, you will see basically for lawyers, and you can look under that. There's Office of Lawyer Regulation. You can go to there, or there's also a direct link to the trust account program page. And I would say, if anyone's interested, we do have a seminar that we're doing trust account management seminar. We do it every year, usually in September, and it's 4 CLE credits. So if you have any lawyers that you think might benefit from that, it's coming up on September 22nd, and it's basically trust account management 101. We do an hour on all the new stuff, kind of like what we just talked about now, but we also talk about record keeping and all the general duties. And it's open to lawyers or their support staff, and it's 4 ethics credits. So I'll tell you, it's free, but so that's a good thing.
Okay. Question from a viewer says the rules make electronic transactions easier but also faster, which sometimes mean that errors happen before they can be avoided. Since July 1, what are the most common alleged violations you see, and do you have a top 10 list of provisions that are violated most often?
Oh, wow. It's funny. I actually have another presentation. It's the top 10 trials and tribulations of the common things that we do see. But we haven't seen since July 1st, we haven't seen a whole lot. But it's a great point that the transactions do move quicker. There's less room for error. So you do want to make sure that you have all of the correct account numbers in there, the correct account names, and so forth. We have seen, I've seen a couple of, there was a fraudulent ACH payment was taken out of a lawyer's account last week, and I don't think it has anything to do with the rule changes, because that could have happened either way. But the bank was able to track it down and refund the money. But the fraudsters, they keep up,
Yeah.
So they're doing their best to figure out the electronic systems as well. So that's just another reason to keep up with your bank, take note of any advanced security things that they're offering, and consider whether or not it's worth your time and effort and expense.
Okay.
And I would, on the top 10 thing, I should probably touch on that.
Yeah.
But generally, what we see, the kind of the causes of overdrafts and the things that we see a lot is, cutting, like I said, cutting checks from the wrong account. It seems obvious, but transposing numbers, just getting the wrong amounts either on a check or an electronic transaction, that it causes kind of a cascading effect, because if you get the wrong amount now, you have the balance wrong, and then it just can screw up the rest of your transaction. So we really recommend that people double check the amount, and while you're doing it, that's the time when you should make your trust account record entries, because you want to make a record entry that goes into your general transaction register, and it should also be reflected in your subsidiary client ledger that shows exactly how much money is in your trust account as a whole, and also how much you have for client Jones, when you're before and after you issue a check. So we always recommend that you contemporaneously create the record at that time, because it helps you keep keep track of any errors, and also it makes sure that you're duly accounting for the funds.
Okay. And another viewer wrote in, just to clarify, we can electronically transfer funds from the operating account to the trust account for expenses, and no longer have to write a check between the two accounts. Can we also electronically transfer once fees are earned from trust to the business account without writing a check? That would be very good news.
Yes.
Okay.
Yes.
Good news there, Tracy.
No longer have to cut a fee disbursement check from your trust account payable to your law firm and then put it in your operating account. You can transfer those over. So that was a big thing we want to do. So yes, you can transfer directly from your operating account to your trust account, vice versa. But again, you want to make a record of that in your trust account records, so that you have it and you can account for it later.
Okay, well, good. Well, you made our attendees happy, it sounds like. Matt Beyer, our Senior Vice President at WILMIC, who also does some claims work for us, is watching and has jumped in here just nearly. We're just about out of time, but Matt wrote, as WILMIC policyholders, our insureds have additional benefits in the form of grievance counsel coverage. We do encourage our policyholders to use that benefit when a grievance arises, and that includes trust account violations. We think it, as Matt writes, we think it allows for a smoother investigation process and takes some stress off of the insured. His question to you is OLR generally receptive to that for trust account violations?
Yes. I mean, it's not uncommon for lawyers to have insurance policies and to be involved, for the insurers to be involved in a grievance process, and also, just as a side note, lawyers always have the right to counsel in any investigation with us, so they're welcome to get their own counsel. As of course, as we all know, we the doctor makes their own worst patient, right? So right. If you're a lawyer looking at it, and if it's a significant thing, you may want to consider if you want to get counsel on that. So
yeah, and that's one of the reasons we encourage them to use that. Consulting, getting a lawyer's perspective on it other than your own,
right,
can be a good thing. All right, just about 10:15. I don't see any of the questions coming from the online viewers. Anything here? No. Okay, very good. Travis Stieren, Program Administrator at OLR for the Trust Account Program. Travis, thank you so much for coming in today.
You're very welcome.
Appreciate it very much. Thank you all online. Stick around. We'll take a 15-minute break. At 10:30, we will be back, and Aviva Kaiser will come in to talk about artificial intelligence and how that affects you as a lawyer. So stay tuned. Thank you. All right, we are back. Thanks for coming back to join us. I hope you enjoyed the first half of the program. That was very interesting. A lot of trust account rules to sort through, as you well know, Aviva. So here we are, 10:30, second half of the program. My name again is Tom Watson, President and CEO of Wisconsin Lawyers Mutual Insurance Company, WILMIC. And we are in the midst of another annual summer seminar. So thank you for joining us, all of you online, and for those of you here in person as well. The second half of the program deals with artificial intelligence, AI, ChatGPT. With us is Aviva Kaiser. Aviva is ethics counsel here at the State Bar of Wisconsin, a longtime friend of mine and somebody that I rely on quite a bit as a resource for all things ethics and rules. So, Aviva, thank you for being here. I was looking through your material this week to prepare for this program today, and I thought, okay, I've never done anything with ChatGPT or anything like that. Nice. So I signed up, and the first thing I put in was design a 500-word essay on lawyers' legal professional liability insurance, since that's the business we're in here at WILMIC. And it's in about 10 seconds, it spit out a 500-word essay, and it was accurate. There was nothing inaccurate about it. It was very general. Okay. Then I typed in design a 250-word essay on the state of the Boston Red Sox, my team of choice that I root for, and it spit it out, but it was very general. It didn't reference this year's performance of the team or anything like that. I've just talked about the historical franchise and so forth. So those things are my first foray into AI. But I certainly have read enough about lawyers who have used AI and some lawyers who've gotten into trouble using AI. As they file court motions and petitions and briefs and so forth. So it's an interesting concept. I think it can be useful. We had a conference last week where companies like ours in other states, we all gather once a year and talk about the stuff we're doing, and several of representatives at other companies around the country that do malpractice insurance were talking about how they actually have used AI for some things, and many of their lawyers have as well, and they found it to be very useful. It kind of scares me a little bit, but maybe that's because I don't know that much about it. So you're here to tell us all about it, how it works, and the risks.
Well, I hope it'll help, but I know that... How's my mic, guys? All right. So while you were talking, I just wanted to start with something really funny that came up. So French speakers right now, because in French phonetically, ChatGPT sounds exactly like cat I farted. So you can imagine what this is doing on the news. Yeah. If you need to take that out of the recording, you can do that. But anyway.
Well, those of you who have been watching, you got a live version of it right there.
Right there, right. But it just, again, tells us a little bit about how new this is and how exciting it is, but how frightening it is. And you're absolutely right about the frightening part. So why did I call this When James Joyce Met Vladimir Lenin? So I'll tell you why. So I asked ChatGPT, how did James Joyce meet Vladimir Lenin? Now, the reason I did that is we'll talk about how you phrase questions for ChatGPT, but embedded in that question was the assumption that they actually did meet, right? I probably would have gotten a different answer if I had said, did they meet? But I asked it this way, and here's what it told me. James Joyce and Vladimir Lenin met in Zurich, Switzerland in 1916. Both men were living in exile in Zurich during World War I. Joyce was a writer and Lenin was a revolutionary. They met at Café Odeon, a popular gathering place for artists and intellectuals in Zurich. So look at the detail on that. What would you assume? It is accurate, right? However, it's a hallucination, not by you, but by ChatGPT. So we're going to start with what is that hallucination. Some of the places now are calling it mirages, but they are really hallucinations. So
they're not lies?
No, we're going to get to that in a minute, why they aren't lies. But what happened is, how does ChatGPT gather this information? So I did some research. So I found a New York Times article from 1991 that talked about the Joyces moving to Zurich. And after Italy had entered World War I, they moved to Zurich, they lived there. And in the 20s and 30s, even though they were living in Paris, they went to Zurich. James Joyce actually went to Zurich because of his eye surgery that he was needed. But his favorite haunts never included that cafe. Lenin, on the other hand, moved to Zurich in 1916. He left in 1917, so he was there a little bit more than a year. But there's no reports that he ever visited that cafe. There's nothing that suggests that they ever met. However, when I asked that question of ChatGPT, it had access to that information. So it assumed, okay, they met, and now we're just going to scour our database and put this story together for you. But you can imagine how difficult it is for us to distinguish what's accurate and what's not, especially when you have that level of detail, right? And when there's some truth, if you know a little bit about Lenin and Joyce, you know that they were in Zurich approximately the same time. So, but that's how that hallucination started. So why do we call it hallucination? So Bloomberg had a great article about this, and I included some quotes there. But, you know, that's what everybody says now. The minute there's anything that AI is inaccurate about, they call it hallucination. That's the default explanation. And so it's a great metaphor, right? We hallucinate. We see things maybe that aren't there. I do that all the time. We hear things. You know how you can't remember something? You think you read it and you look everywhere and yeah, you didn't. But anyhow, there's a lot of reasons for that. But none of those reasons really deal with what AI or the large language models are. And I want to be careful because AI, we all use AI. How many of you use Grammarly, right? Or any of this? That is AI. It's not a large language model. So we're going to distinguish between those in a minute. But you know, the problem is that every company that's now using these large language models refer to it as hallucinations. And again, there's some that call it mirage, but that's not any better. So what did, oopsies, so why is hallucination wrong? What does it do? The problem is, as Bloomberg pointed out, it really obscures what's happening with that technology. You know, it's like, as Bloomberg said, oh, it's not our fault. You know, it's just hallucinating. But the problem is that doesn't make those companies responsible for what they're doing. And we'll see some great examples of that in a little bit. But it is a problem with that vocabulary. So I'm going to talk a little bit now about what ChatGPT, what that technology is. So I thought you'd like to know what ChatGPT stands for, or GPT stands for. And if the French use that, then they probably resolve that issue. But it's Generative Pre-Training Transformer. I'm not sure what that means, but it's, you know.
Yeah, that doesn't help us much.
No, it doesn't. We think of the Transformers, you know. I just had my photo taken in the Dells outside of that the White House, and with those huge transformers. Yeah. Anyway, so one of the things that when ChatGPT 3.5, I should say, came out in November of 2022, remember, it just took the country by storm, or the world by storm, right? Everybody was looking at, except for Tom, everybody was looking at ChatGPT and asking questions, and it's free, right? Then when ChatGPT 4 came out, which is much more sophisticated, and you have to pay for it, of course, in March of 2023, that really, made the game much stronger in terms of using AI and using large language models. Microsoft invested a whole lot in OpenAI. You'll see that Bing uses it, Google uses it. Some of the law firms are actually using that basis, and they're using their own data. So they're not using the open data that ChatGPT does, but they're using that technology. So there's just so many neat things. And if you haven't played with it, it's fun. I asked it to write a sonnet for me for Valentine's Day from my husband, and in the voice of Shakespeare. It wasn't bad, and at least I got a card, so hey. But again, you want to be cautious. Again, that GPT is a natural, what we call natural language processing task. So as I explained, what it does is it looks for those cues from what you asked it, and it gathers that information. So there's actually companies now that do help you formulate what you should ask to get a better result. So,
hey, Aviva, let me just ask you.
Sure.
So, this kind of strikes me. Again, you're talking to a guy who still reads the actual newspaper. I open the paper and all that.
I love the way it gets print all over your hands.
Yes, right. But it strikes me, this is really interesting, and I do a lot of writing. I write reports to my board of directors, to policyholders.
And great articles.
Well, thank you. Risk management articles, certainly.
Yeah.
But I feel like if I ever tried to use this technology, it almost would feel like plagiarism in a way. I would lose that genuine uniqueness that is my writing. And maybe it needs some help, but I don't know how, as lawyers use this stuff, is there that element there that,
There is, and we're going to talk a lot about plagiarism, but what you really mentioned is what humans add to this is judgment, empathy, creativity, adaptability, and the GPT technology or the large language model technology is just not there yet. Mm-hmm. So to the extent that you need that in your work, ChatGPT or any large language model is not going to help you. But on the other hand, one of the things it can do, and we'll show you, is it may give you a basis. And I think what lawyers have to start doing is distinguishing levels of use. Like, when can you use it? And there was a great article in, I think, Inside Track, this just last version of it, where they talked about, here's these different levels, and maybe we'll get to that in a little bit because I think that's helpful. But think about what ChatGPT can do. It can translate from other languages. Now, we've used Google Translate. Anybody use that? Yeah. It's not great, right? But
Google, what's that?
Yeah, Google, right?
I do use Google. Google's great.
Yeah, Google's great. It starts with a G. Anyway, but answering questions, writing code. I mean, I'll have an example for you where Samsung actually had difficulty with their code. They uploaded it into ChatGPT to help, because ChatGPT can code, but we'll realize that they entered proprietary code into a database that's accessible by a lot of other people. So you want to be careful about that. But there's so many uses for it right now. And as we're finding out, and maybe this is the place to talk about. So when I started law school in 1975, oh my God, there was no Lexis or Westlaw. There was a dedicated terminal for Lexis that was in the law library under lock and key, and only faculty could use it. So my training when I was in law school had nothing to do with computer-assisted legal research, which uses algorithms, right? So it's a part of what we think about as artificial intelligence. But we now use that, and it would be, so the first times we looked at what competence required, everyone said, no, you don't have to use, this computer-assisted legal research to be competent. But then, as things happen and you realize that, remember the book Shepherds, anybody that you had?
Oh yeah, of course.
Right. So they're not up to date. But so we started seeing more cases that for competence, what normally, prudent lawyers would use included electronic research. But remember those first queries that you did? And you got all sorts of things that just didn't make sense, and you missed a whole lot of things that you should have found because we weren't trained on how to write those queries, especially because they weren't the natural language searches that we have today. They were those Boolean searches. Yeah. But That's what's going to happen, I think, here. If lawyers don't start learning about the pitfalls here and how to use it appropriately, there are going to be times where eventually lawyers' competency may be called into question. So it's something for us to look forward to, I suppose. So when we talk about large language models, what we're talking about is that machine learning model that all it does is classify text. It takes that and puts it into a conversational manner, right? Whether it's translating or just answering your questions. But if you think about the massive database that it's trained on, right, it actually looks for models and patterns in your structure and language. So that's how it comes out sounding like a human wrote it. And that's the frightening part, right? When we go back to how Lenin met Joyce, right? The problem is it sounded like a human wrote it. It was drafted well enough and it was conversational. So what happens here is that it gives you what it thinks you want because it's looking at those patterns and it's looking at the pattern of your questions and then it's finding that information. So again, it's providing that model. It doesn't mean that it's accurate. And that's the thing that is frightening at first. So I asked GPT what it can do because I thought, all right, I'd go to the source, right? The horse's mouth. Look at this, what it says about itself. Generating a highly coherent, contextually appropriate text. That's, I guess we should say caveat emptor here, right? But that's pretty fascinating. Generating complex documents that require a high level of language accuracy and precision. Notice it's language accuracy and precision. It's not content accuracy and precision. Summarize legal content for marketing purpose. You'll see later in one of my examples, I asked it to do that, and it did a fairly good job. Provides highly accurate and precise language generation for professionals. So maybe it would help us choose appropriate words. And then again, you're going to have to play with it to see if it's going to be useful for you. All right, so we're going to talk about
the one thing on that list
Sure.
that jumped at me was the creating or generating client communications and
Yes.
legal arguments. Now those can be very fact-specific
Yes.
documents, and that's where I start to feel a little nervous about this type of thing.
Yeah, because what you're going to be doing is entering information about your client.
Yes.
So we're going to talk about that 1.6 duty because we don't know how all that information is saved, how it's accessed. So that's going to be
Right.
important for us to remember. But when we think about legal arguments, we saw what happened with that recent case with the lawyer with the 6 cases that were not real cases. So we'll take a look at that. But again, if this is promising what it can do, you can see why they're using the term hallucination, because this must have been drafted by a lawyer because it's not saying it's factually accurate. So we'll see. So here's the ethical issues we're going to talk about. So I asked it what ethical issues were raised. I wanted to give it a chance to defend itself, right? So it responded that there are a number of legal and ethical issues raised with ChatGPT. It also includes other large language models. And it entered privacy, bias and discrimination, misinformation and manipulation, autonomous decision-making, and intellectual property. So those were the issues that ChatGPT recognized. So I wanted to ask it about each one to see what it would say. So with bias and discrimination, we know that those large language models are trained on information that's out there. Existing biases are going to be there. So those biases can be amplified by ChatGPT. And I'll give you an example that's really an old one. You may remember years ago, Amazon worked for 10 years to develop artificial intelligence to evaluate its applicants for its high-tech jobs. Spent a lot of money, and in 10 years, what did they find out? It was biased. Why was it biased? Because all the applicants that they fed into the system were generally men, and not women, and so it was biased against women. And why was that? Because the model taught itself, first of all, what words did men use that women didn't use in their cover letters or on their resumes? So they used words like captured or this, or, strong male, what we consider strong male words. Women did not. It also looked at not only where you went to college, but it also looked at what your majors were. So traditionally, male majors were ranked higher. If you had a women's study major or anything like that, it was low. Your score was lowered. So again, none of it still was capturing all the discrimination and bias. And if ChatGPT is trained on all this data that's out there, it's going to include that data. So we have to be careful about that. Privacy concerns, again, it's trained on all the information that's out there. If you have sensitive information that you're uploading into ChatGPT, any personal details, that raises questions. How is that data collected? How is it stored? Who has access to it? And we know that under our duty under 1.6, we have to be really cautious. So in those client letters or briefs, if we're entering information in there, we may be violating Rule 1.6, and we'll talk about those rules a little later. Misinformation and manipulation. Again, we're seeing that as with, I picked a bland example about Lenin and Joyce, but you can imagine asking it a loaded question that would get information that would generate that text that's convincing but not be accurate. And can you use that for any malicious purposes, and again, creating fake content. So we have to be cautious about that. And remember, people may be confused about what ChatGPT says it can do when it talks about accurate language, but that doesn't mean facts. This concerned me as well, autonomous decision making. Remember, we're paid for our independent judgment, right? We're paid to exercise our legal reasoning and our skill. But here's the problem. If we're allowing, as that one lawyer did, in the New York case, we'll talk about that. But are we ceding our autonomy as a lawyer and our judgment as a lawyer to a tool that we don't know? And AI is a tool. Large language models are a tool just like any other tool we use. And so I have really questions about this. So the lawyer who made up those, used the ChatGPT to make up those 6 cases in his brief, again, he didn't use his independent judgment.
Yeah. That's the thing of it, Aviva. Years ago, say 30, 40 years ago and beyond that, clients would come to lawyers if they needed, particular legal forms. Mm-hmm. Nowadays, legal forms are a dime a dozen, really. You can get them all over the place.
That's right.
And we have LegalZoom and all that. So lawyers' stack and trade now is, as you mentioned, the expertise, the experience, the ability to frame the right legal questions, right, and all of those things, which can't be recreated through this type of electronic platform.
And remember, on your cell phone, you can get that app that will draft a contract for you really quickly.
Yeah.
And you just to some degree, it's already been there for a while, because I've had that app on my phone for ages. Intellectual property we talked a little bit about, but so there's a couple questions, not only the plagiarism issue, but once they generate that text, who owns the right to that text? And we'll talk about the liabilities too, as you'll see a couple examples. But the other problem is we don't know how that, so when I asked it to write a story of a bar fight in the voice of Hemingway, it wasn't bad, right? And then I tried to use plagiarism checking text to see if it was actually plagiarized, and I didn't get nothing said it was plagiarized. And I don't know, some of those like turn it in, look for 7 words or 10 words or, maybe even more. So I don't know, but I would certainly suggest that anytime you're using ChatGPT or any other large language models, to run it through a plagiarism checking so that you can see if it's, because if we're putting out there on our own and ChatGPT has, sort of used that language and it's not citing it, who's responsible? And the bottom line, I think it's going to be us. So I asked, and this is why I put you off, I asked ChatGPT if it should be cited to avoid plagiarism claims. And it told me yes, obviously. But it said that if you're generating text in any form of publication, it should be cited to. There's a couple reasons for that. We'll look at rules. We have to be honest under 4.1. We can't be involved in misrepresentation under 8.4c. And the question is, if we're saying we wrote something and we didn't, and if you're submitting something to the court under 3.1, so you want to be really cautious about this. I was just surprised that a number of courts now, and I didn't bring the whole list in because it changes hourly almost, but so many courts now require lawyers when they're submitting their briefs or any documents that they have to have an a statement there saying if you use ChatGPT that you did, or if they don't allow you to use it, that you've conformed your conduct to that. So again, just be careful if any of your local court rules are addressing the use of large language models or ChatGPT. So I asked ChatGPT if it made up citations. So this was interesting. It said it does not have the ability to create citations or reference sources on its own, but it can generate text that may contain citations or references if it has seen examples. And this tells you how large language models work, which is I wanted to, okay, so I committed a major offense here, by the way, in terms of legal research and writing and knowing my background. You should do it. You should never use 2 forms of italicizing and underlining. Never do it, but I did it here. But it's so true. I mean, what that says is we didn't make up that citation, but we know from the model what it's supposed to look like. And so we just filled it in from other data that's there. So what does that mean? Again, it's really accurate. Their citation form based on the Blue Book was pretty good, but it wasn't real. So what they're telling us is it's accurate in terms of form and in terms of language and construction, but it's not accurate in terms of what the content is. So one of the things it did say is it's not able to verify authenticity and that it's important that lawyers are using it, anybody using it should make sure they check it. So let's talk about rules for a little bit, because I know that's what we're here for and you love that. It's really hard following Travis because, it's so exciting and this is just rules. But anyway, let's see. So the umbrella rule that I want to talk about is 5.3. SCR, I leave off SCR 20 because it takes too long to say it. But anyhow, that's an umbrella rule. What that rule tells us is every law firm has to have in effect policies and procedures to make sure that all non-lawyer assistants follows the rules. Notice this rule says assistants. It used to be assistant, A-N-T, referring to people, but now we have so many parts of our practice that aren't people, or humans. They may be cats, but no. So anyway, you want to be cautious because now the problem is when you look at that 5.3, there's 3 parts to it. Part A is that big picture. You have to have those policies and procedures in place. Part B is the lawyer that is directly supervising that assistance has to do the same thing. Make sure that that assistant's compatible with our rules. Then paragraph C of 5.3 is very interesting. It will make the lawyer vicariously responsible for any any violation that the assistants may have committed if that lawyer did not, well, if the lawyer ordered it, so that's it. But if the lawyer knew about it at the time and didn't take remedial measures, that lawyer is going to be responsible. So if I'm supervising the lawyer that was using ChatGPT to write a brief and I didn't say, hey, did you check those citations? Did you do this? Did you do that? I may be as equally responsible for that conduct of that lawyer using ChatGPT as the lawyer is, or as ChatGPT is.
The first of the three parts of 5.3, it doesn't say written policies and procedures. Is that a critical thing, or am I just nitpicking here?
It does. The rule doesn't say that, right? It says policies and procedures in place.
So a firm may not have anything in writing.
They may not have anything in writing, and then that makes it tough if you have to defend them.
Right.
And one of the comments to 1.7 and 5.1 that deals with lawyers basically says it depends on the size of the firm. So if you're a two-person firm, are you going to have a handbook with policies and procedures, or is it going to be, here's how we do conflicts checks, right? There's two of us. But the problem is, without something in writing, I think it's harder to defend, and you would know probably better than.
Yeah. We had a claim a few years back, Aviva, and it was an assistant had produced some material that had to go out, and one of the defenses the lawyers gave us was that he was on vacation, and so it wasn't his responsibility. And we had to have a little education about you're the overseeing lawyer here, and so that would apply not only to an assistant person, but also ChatGPT or whatever you're using.
Right. So again, even ChatGPT said that it's important to have those measures in place to mitigate harm. So it's interesting. The more I would go over this material, the more I would see is they're telling us, here's all the great things we can do, but, and they're carefully worded, but then here's all the risks you take and what you have to do to mitigate those risks. So again, lawyers have that duty to manage. And if you look at the ABA comments under 5.3, they're not particularly helpful, but how do we exercise that judgment when we don't know how it works? And this was, when you think about, we've talked about this before, the COMPASS program that predicts recidivism, and it's used in criminal courts. We already know it's biased. And there's a disclaimer on it that it's biased, but we use it, right? So what does that mean for technology like this, right? So we have to make sure that it's going to protect confidentiality. We have to make sure we're doing competent representation. We have to, verify the accuracy. We have to exercise our professional judgment. All the authenticity of all those texts and citations. We have to ask ourselves, how are we going? If we don't have a policy that says how everybody must do that, I think we're at risk. And actually, the State Bar has been working on its policy, so good for them. So we know that 1.6, so we've talked about the overarching 5.3, but 1.6, again, when we think about our confidentiality rule, it is so broad. It covers all information relating to the representation of the client, regardless of the source. So if I read something in the paper about my client, it's protected. I can't talk about it to somebody. Everybody in the world can talk about it. I can't, unless my client gives me informed consent or it falls within one of the other exceptions. One of the other exceptions does not include uploading this information into ChatGPT for the purpose of, producing a document. But the other thing about 1.6 that a lot of us don't realize is not only does it cover disclosures, but if we look at that ABA comment 4, it covers information that could lead to the disclosures. So in the harmoncation of the lawyer was disciplined because the lawyer didn't give out the information, but he said, you can find that in this deposition, in this, court file. So we have to be really careful. And the other part of 1.6, it's not one of those rules that it's no harm, no foul. It's that's the prohibition, disclosing that information. So even if we as lawyers think it would be harmless, it still violates the rule. So I think a lot of lawyers think, well, I didn't say too much. In fact, I had a call this morning about that. Well, I didn't really say too much. And that's a really tough rule for lots of reasons, but that's another CLE, right? So how do we act competently when we don't know how that information is stored, who has access to it, or even how it's gathered, right? When you think about how many of you have the dictation on your phones, right? Well, that program listens to everything you say because it's training itself on that, right? So what does that mean in terms of what information we're putting into that program? Again, we don't know a whole lot about this. I think as it becomes more, ubiquitous, we will probably learn a little bit more about the technology. Whoopies, we gotta go forward here. Okay, you're not going forward, why not? Here we go. I must not have been pushing hard enough. Such a gentle touch here. So what's our duty of competence? So 1.1, we know that what do we have to be competent in? Knowledge, skill, thoroughness, and preparation. So where does ChatGPT fit into that? Comment 8, right? What does it tell us? We have to keep abreast of the practice of the benefits and risks associated with relevant technology. So what does that mean for us? Well, it means we have to keep following and saying, what do these large language models do? How can they be used? What are the risks? And when we identify the risks, we have to say, well, what measures do we have to take to compensate for those risks? And again, this is new, but I would just say verify everything. So then you're asking yourself, does it really save you time, right? Ethical duty of truthfulness and honesty. We talked about this a little bit before, but remember, under 4.1 and 3.3 and 8.4c, you're not permitted to make false statements. So what ChatGPT told me is that because this model is not able to verify any authenticity of anything, the sources or the text generated, there may be inaccurate citations present in that training data. So if we provide that to the court, are we violating 4.1, 3.3, or 8.4c? And if you notice, 8.4c says that a lawyer, is prohibited from making statements that are, fraudulent, deceitful, involve misrepresentation. And so suppose we could argue that we didn't intend to do that, but if the rule doesn't say knowingly or intentionally, then I would make sure that we check all that.
The takeaway for me a little bit on this particular point, Aviva, is, that ABA comment about a lawyer's duty to keep up at least, on the surface anyway, or at least to have a working knowledge of technology, which is about 10 years old or so? Is that when that comment sort of came into?
That's been 2012, I think.
Okay.
That maybe. So
11 years, yeah. And that was a thing that lawyers talked to us a lot about. It's not okay to say, well, I don't know that much about technology, so I didn't know what it was going to do or how it was going to work. If you're going to use technology, or if you're going to use ChatGPT or whatever you're using, it's no longer an excuse to say, yeah, I just didn't understand it.
Right.
And that's been the case, as you say, with the ABA rules and the Wisconsin rules of professional conduct, at least 10, 11 years going now. So I think lawyers should certainly be aware of that.
They should be. And, the real difficulty when you think back about all the other different technology we started using, think about e-filing, right? How many lawyers, when they were e-filing, included Social Security numbers or all sorts of things that shouldn't be in there? And I don't know if you have any cases about those.
Yeah, none that come off the top of my head, but our claims attorneys might be able to refresh my memory on
Right. Yeah, you may not want to know.
that. Yeah, right.
But it's one of those things that there was that learning curve. Mm-hmm. And so I'm sure there will be mistakes, but to the extent that we can be prepared for those is probably better. What should we do about that ethical duty of truthfulness and honesty? When you look at 3.3, candor to the tribunal, the lawyer shall not knowingly make a false statement. So is it knowingly making a false statement when you're submitting a document that over your signature that was actually written by a large language model? And I think that is knowingly. So it's kind of a meta argument, right? Don't we love meta? So not only are you being dishonest by saying, this is what I wrote, this is what I did, but if the information in it is dishonest as well, then what? So I would just be so cautious of again, if there's one thing to remember from this is always check the accuracy of anything that you're using. And again, that 8.4i, to refrain from discrimination or harassment. If we're using ChatGPT or any large language models that have that bias built into it, we should just be so careful about that and just, be very aware. So, by the way, Wisconsin, I always put this in there because our rule basically says harassment. And the Supreme Court, as you may know, did not approve our petition to change 8.4i. But the Wisconsin comment includes discrimination in the case law, even though harassment and discrimination are different. The case law, or at least according to our Wisconsin comment, that we can use both discrimination and harassment. So we know that ChatGPT acknowledges that that's an issue, so just be careful about it. Great. Let's see, next thing. Here's another one. We don't think about 4.4a very often, but it prohibits that lawyer from using means that have no substantial purpose other than to delay or burden a third person. So oftentimes when we're thinking about bias and discrimination, it's also a violation of that 4.4a. And it could very well be that using something in your briefs or memos that has information in there that's not accurate, it may very well fall within that rule too. So, and then our duty to exercise independent judgment. This is a rule that it surprised me very few people talk about or know about it. But the reason I like this rule is it tells us that rarely is pure legal advice enough, and it gives us the ability to talk about moral, socioeconomic, political, any kinds of, information that may help our client make a great decision. So again, if you ever, and I should probably look at that, if you've ever not looked at that 2.1 as an advisor, it's a great one to look at. It says, in rendering advice, a lawyer may refer not only to the law, but other considerations such as moral, economic, social, political factors that may be relevant. So again, keep that in mind. And in the comment, it tells us that rarely will we find that just pure legal advice is enough. So, which is, again, the reason I highlight that is what ChatGPT or any large language models cannot do is exercise judgment, empathy, creativity, or adaptability. So that might be helpful. All right, the parade of horribles. Are you ready? It's my favorite part. All right. So this is the case that we talked about, where the 6 in the motion, response to the motion to dismiss, 6 cases were cited as precedent. They didn't exist. They were bogus judicial decisions, and by the way, they were actually attributed to real judges. So when the lawyer was sanctioned, part of the sanction was the lawyer had to write to all the judges and apologize for attributing to those judges cases that did not exist. lawyer was only fined $5,000, so that's not terrible. But here's, again, this is like the explanations you've seen, right? That he didn't know. He heard from his college-age children that this was a great source to use, and he didn't realize that it wasn't research, that it was actually a large language model. But again, that's no excuse for not looking up the cases and reading them.
Yeah.
It's like people who read the head notes, right? And that's all they did was read the head notes, and they weren't sure. So again, there's a lot of analogies to what we really do now. So this is a tool. I don't know that we need different rules for the tool. It's just we have to start thinking about how those rules maybe apply to those tools. This is the Samsung worker issue. So again, they decided to try and fix their code by putting it into their ChatGPT. So you want to be careful about that because now it's available to everybody else. So if you have a Samsung phone, no.
I don't. I have a Samsung TV, though. Is that listening to me?
Well, it may be.
Yeah.
I have some stories about that as well. So this is, you know how it tells you want to watch things that, are similar. I see everybody shaking their head. Yeah. So this is one of my favorites. So a law professor had been accused of sexual harassment during a class trip to Alaska, sponsored by his law school, Georgetown University. The professor was Jonathan Turley, and so for some people who may know Jonathan Turley, you may not like him and think this is, But on the other hand, he's not at Georgetown. He's at George Washington. He'd never gone to Alaska. He'd never been accused of harassing a student. But the article, and the supposed article in the Washington Post reporting on it, didn't exist. So another favorite person of mine was Eugene Volokh, who asked ChatGPT what law professors, to make a list of law professors that were accused of sexually harassing somebody. And Jonathan Turley's name was one of them selected. Now, again, when you think about how that large language model works, they ask the question, what professors were accused of it? So they're going to look for law professors. They're going to look for lots of different things. And it came up that Jonathan Turley was one of them. And he wasn't. So now the whole issue is arising, can you sue ChatGPT for libel? And we won't know the answer to that because it may not be liable, it's just a hallucination, right? So I found this one to be kind of interesting. So they have these writing competitions, right? So here's a magazine, a literary magazine that received 700 submissions by humans and 500 by AI, and they had to close it down because they were just so overwhelmed. It was interesting. They said a lot of them were written poorly and had the same title, but still you can see when we look at that plagiarism and should you be citing ChatGPT, what if you would actually win one of those that was generated by ChatGPT? Did you cheat? I would say so, but I'm kind of old-fashioned that way. All right, come on.
Aviva, you're on the ethics hotline a lot. Are you getting questions from lawyers about using this kind of AI stuff, and do you have any sense of how popular it is out there?
No,
Okay.
not at all.
Yeah.
I've been surprised, but a lot of lawyers aren't familiar with it. Then after presentations about this, they'll come back and say, well, we didn't know anything about it. So, but we'll talk about maybe what firms are going to be doing, and I think there's probably going to be more usage, I would say, in the next couple months.
I'm waiting for a claim or a grievance to come our way.
Yeah.
As a result.
This one really bothered me. So here, a widow in Belgium said her husband died from suicide, and what happened was he was talking to this chatbot, Eliza, formed a relationship with her basically, and was talking to her about suicide. And she said, well, if you wanted to die, why didn't you do it sooner? I'm saying she because the bot was given a female personality. But so he committed suicide. And I mean, what do you say after that, right? Okay. My touch must be terrible. Okay. So ChatGPT did have a bug. This was just a really quick one and it happened in March, really right after ChatGPT 4 came out. But they found that they were allowing users to see titles from other chat users' history. And I can go in and see all my history on my ChatGPT. So, and some of the personal data was revealed. So again, I know that OpenAI is working really hard to make sure that data is protected, but we just don't know enough yet. All right, so I thought you would like this. What 20 jobs will be replaced by ChatGPT? And this is what ChatGPT told me. Notice how the breadth of this. Okay, customer service, technical writers, translators and interpreters, copywriters, journalists and reporters, editors and proofreaders, my favorite, content creators, even though we know that content may not be accurate, legal document reviewers. How about academic researchers, teachers and professors? That was medical transcriptionists, speech therapists. Again, you can just, I was surprised to see this, frankly, but.
When I saw legal document reviewers on that list, number 12, I thought of the young associates that started at firms, and historically, or traditionally, their job was often, at least for starters, to review legal documents and do some legal research and that type of stuff.
You could sit in that room and just box the documents.
not the fun stuff. They'd go to law school after watching the legal shows on TV, and they looked so glamorous, and then they'd sit in a room and do legal research. But at any rate, if AI does in fact eliminate some of those jobs, I wonder what the impact will be on the legal profession in terms of the makeup of law firms and the jobs that are available to.
I have a graph for you.
Okay.
All right. So, wow, this is great. Did you read this before? So,
you know me, Aviva. I always come up with questions for you.
You do. So, again, there's just a couple things that are happening here, like Copilot. But what was interesting is the law firm that Allen and Overy had actually, and I think there's this called Harvey, where they're using that technology, but the only data in there is their own law firm data. So they're protecting the security of their data there. But again, and I'll just show you this chart. If you look at, hopefully you can see this really well, but lawyers and law firm for document review, 71% of those jobs may be obsolete. But we already have that now. How many document review services do we have now that don't use individuals? Now, there's a number of great malpractice cases about that, and one of my old firms in Chicago. So, and then 68% for librarian, knowledge, and manager and research. Knowledge managers, I don't know what that is, but paralegals, 41%. Marketing and business development, that's pretty low. And that would be the area you would think that would be higher, right? HR recruiting, and then IT. But the lawyer, law firm, solicitor, that's really low. And I think that's because when you get to that level, that's where you need the judgment and the empathy and the creativity.
Yeah, you're right. We have a lot of this already, and I don't know how you feel about it. I have not seen a negative impact in terms of jobs available. I mean, law firms are hiring law school graduates the last few years, so it has not had a negative impact on that.
Yeah. But that was really costly when you think about lawyer salaries sitting in those rooms and reviewing all those documents. And now, and that's the other thing. How do we add value to what we do for our clients? And this is one of the ways when we look at AI, it does add value. The question is, how do we make sure that what we're doing is right?
Well, and we're not talking billing or fees or anything today, but that goes to also the hourly rate. The hourly billing model. If this stuff is getting done much faster, presumably you're billing less, but then you get to your question of what's the value that you're giving to your client.
And do you raise your rate?
Right.
So this is under the your parents must be so proud. ChatGPT 4 didn't just get into law school, it passed the bar in the 88th percentile. Okay, and on the uniform bar exam, it scored in the 90th percentile. But you can see the difference from ChatGPT 4 and ChatGPT 3. ChatGPT 3, it was in the bottom 40% of the LSATs and 10% on the bar, so a big difference there. If you look at the GREs, it scored in the 80th or 90th percentile for all sections except for writing, which I found really interesting, since it prides itself on accuracy in language. And so the next one is, which is really important, is it didn't do well in Calculus BC, but when my son took that in high school as a senior and he wanted me to help him, I didn't do too well in it either, so we're okay. But the sommelier exam, here is something that never tasted wine. It passed with flying colors, and even 77th percentile for the advanced one. I just use that wine app, and I look it up all the time. All right, so some cool examples. Whoopsies. So I asked it to write a letter to a prospective client and why our firm couldn't represent them. And if you notice, it's not bad. I'm sorry, it went 2 there times. If you look at this, it kind of starts out nice. Thank you for considering our firm to represent you in your legal matter. Great way to start, right? After carefully reviewing your case, would you really want to say that if you were not representing that person? You just risked on 1.18. You're not going to be representing anyone that's adverse to them. Because they're telling you there's conflict of interest. You don't need to do any other thinking about or reviewing their case. It does cite 1.7. I thought that was great. It's conflict rule. And it doesn't give any facts about what the conflict is. Hold on now. I thought this was nice. We understand that this may just be disappointing news, and we're going to apologize to you. Really, isn't that a nice touch? And then, thank you for considering us. So again, starting out with a letter like this and then editing it may be really helpful and give you a great idea. Why am I having trouble getting this forward? So I asked to write a 300-word legal brief for a defendant's motion to extend discovery. This one isn't quite as good. You may want to check the rules and whether or the statutes to make sure it's the right one. But when you take a look at this, it just keeps repeating the same thing over and over again. There's no real factual analysis. And I would imagine that a judge would probably want a little bit more. So again, you'd want to check those statutes. I don't think they're quite the right one, but I'm not allowed to give advice on substantive issues. But it got the gist of it. Granting an extension would not prejudice the plaintiff, would ensure the defendant has a fair opportunity to respond, principles of fairness and justice. So you can see it might be a good starting place. It is repetitive. It doesn't go into a lot of detail, but just does tell you the defendant's illness, but not a whole lot. Again, repetitive, fair opportunity to respond. So that one's a little bit different. So I asked it to summarize this was the marketing one, Brown versus Board, right? And so it's a really fairly good analysis of that case written for somebody who's not a lawyer, right? So if you look at that, prior to the decision, schools were separated by race, and the case was brought by a group of African-American parents who argued about segregation, deny their children equal opportunities. So you can see it's fair. It's really accurate. What do you think? Pretty good? Yeah. Yeah, and if you're going to just put this on your website, now you do you have to say, hey, ChatGPT? Because when you think about it, if somebody else is writing for your website that you have these case blogs, you're supposed to let people know who's writing it if you're not doing that. So would we have to say, this was written by ChatGPT?
That makes me think of Wikipedia, too. People that go out on Wikipedia to get that type of a summary of something.
Yep. That's probably where they got it from. I should check that now. Darn, thank you. And here's what it wrote about the attorney. So 30 years of experience representing plaintiffs in civil rights cases, makes me well-equipped to advocate for clients, whether you're facing discrimination, there you go. It's a nice way of talking about what that lawyer does, if it's accurate. So, all right, I have to do this in homage to Chris Shattuck because he did this. He wanted ChatGPT to write a short paragraph describing why, Chris and me were the best CLE presenting duo in the state. For those of you who know Chris, this is so Chris.
That sounds just like him.
I know, I miss him terribly. But anyway, isn't this great? I mean, it's accurate in the sense that, I don't know if we have this unique blend of expertise and engaging presentation style, but it wrote that on its own. So I thought it was pretty funny. Their CLE sessions are consistently rated as some of the best in the state. Now, that's probably not accurate, I would guess.
Chris might have inserted that one into the summary there.
He edited it, no. But isn't that funny? So anyhow, some of you may know Microsoft Copilot. Again, a lot of this will be embedded. And so if you want to watch, I put the link there to watch about that on YouTube. And I know, because we're running over, huh? Google Bard isn't as good, but you can see, I did ask it how I would write my novel, and that didn't go very well either, but I had some bad ideas. Even Up's pretty interesting now, what they're doing. I found this to be really fascinating because now what it can do is, as it says, level the playing field for plaintiffs, lawyers, and PI cases. Because so many of those cases are settled, it gives you that value. So if actually you put in your information, it will analyze over those 250,000 verdicts and settlements and help you figure out what you should ask for. So again, there may be a lot of uses here so for me as a parent, I do have concerns about how our children are going to learn and how we are going to learn as lawyers. But again, I think that's not for this presentation, but I think it's something we all need to think about. And then here's just some links that if you would like to look at.
All right. That's awesome. Aviva, Matt Beyer with WILMIC has chimed in. He's
Matt.
watching out there. Matt wrote that Clio recently hosted a virtual program inviting presenters, lawyers, to describe how they have used AI, ChatGPT, in their practices. And the experiences ranged from very limited occasional assistance to combat the blank page and come up with language for correspondence or email, to in every aspect of our practice, from start to end of representation. Boy, that would be a lot of use of ChatGPT. Yeah. But Matt writes, based on ethical rules, can we offer our attendees a, quote, risk continuum or spectrum of activities that range from generally safe on one end to don't do on the other? In other words, what are some of the areas of any practice where use of ChatGPT are less risky and generally safe? Are there some out there? Is that something you can quantify at this point? So
I would refer them to John Fuller's article in, I think it was just in our last Inside Track. So if they just look John Fuller's name, because what he did was say there's sort of 3 levels of use of AI. So he talks about level 1 encompassing documents that it completely construct with minimal input. So those kinds of normal contracts, right? And things that, again, won't need that judgment or creativity. Level 2 would be significant portions of documents by analyzing detailed prompts or what the attorney has already written. Again, human input's going to be more critical there. And then I think level 3 was more complex documents based on what the attorney has already written. So and I don't, but he talks about tools such as Lexis Smart Forms, Westlaw Form Builder, Luminance, that allow lawyers to generate those contracts.
Okay. Another question from a viewer. Aviva, you mentioned an app that you use to draft contracts. Can you share what app that is? Thank you, and thanks for your talk today.
You know what?
So the
I'll
app.
put that online because I don't know if I should. Hold on. Well, hold on, people. I will go through my phone now. You don't want to know how many apps I have. We're going to search it. Is any more while we're looking at this?
So there is an app for for contract drafting.
Yep. Hold on.
It's probably an app for everything, right?
I'm
Isn't that what
looking
they say?
at app now. Okay, here we go. It should come up now. Okay, so the one I used was, I think, Larina, and then, which other one? I will get, you know what, I'll tell them because I deleted a lot of these, but it was a really old one. Hold on.
I suppose if you Google it, you'll come up with something, right?
Well, you should. You could do that. Darn. Hold on.
Well, if you come up with it, I can pass that along to
Yes.
the viewer. How about that? We'll do it that way.
Right.
Another viewer wrote in, Aviva, said you were talking about calculus and that
Yeah.
kind of stuff.
Oh, yeah. Thank you.
He said, please remind Aviva, an attorney that is good at math is an accountant. So that's the joke for the day.
Thank you. Yes.
Thank you. For
I still have
submitting
PS, post-traumatic stress disorder from calculus in high school. So, and that was 1971. So we're just,
Yeah.
You know what? I do have to tell you, my teacher said that, because I used to chew gum, and he said that he gave me a plaque that said the cow chewing cud and the gum chewing something, or somehow I like it different somehow. It's the clear, thoughtful look on the face of the cow. Yeah.
Well, we're just about out of time. We're running close, and so Aviva, I guess.
We have a couple more minutes.
Yeah, we do.
Oh, thank you.
do you-
Yeah, it was the
do you have more?
the gum chewing girl and the cud chewing cow, or somewhat alike, different
gotcha.
somehow.
Okay.
Okay, I'm going to look for that. Oh, yes, we do have time for
Well,
discussion and questions.
So, you've gone through a lot of this stuff, and we talked earlier, my skepticism, or at least hesitancy to use this kind of thing. As I said, it felt almost like plagiarism, regardless of what level I or anyone else would use it. But I guess at this point, what do you think the takeaway is for viewers and those here today? Is AI or ChatGPT something to avoid, or is it something to embrace? How should lawyers approach using it? They're out there. They're using it to some degree. At least many of them are. What's your take on it from the perspective of the State Bar Ethics Council?
Wow. Speaking on behalf of the State Bar Ethics Council, so
I know I'm putting you on the spot.
it's the problem is it's there already. So we can't make it go away, right? So that's the first part. Second part is I think about our solo and small firm lawyers who don't have the assistance that some of the large law firms do. So would this actually help them practice and make, and earn more money? Especially if they don't have, the assistance, or if they're just on their own. So many calls I get from lawyers who don't even have, secretaries or anything like that. They
Right.
do everything themselves. So is this a way to help them? So I think the State Bar and WILMIC and other programs need to do is help lawyers sort through these and find the things that are helpful for them. I mean, think about practice management systems like Clio, right? Before they were, in vogue, and I'm trying to think, I was still at the law school when I was teaching a risk management course using Clio. And so it had just started, and they were wonderful. They would Zoom into our class, didn't use the Zoom at the time, and actually talk to our students, and we created files. So, but think about how difficult it was to get firms to adopt those kinds of case management systems, or even stop using Excel to do their conflicts checks. Yeah. So again, I think we have to help our lawyers move in that direction. At the same time, we don't want them adopting it so quickly that they're not aware of the risks.
Right.
And so that's where I think our practice management program, programs like yours and ethics can really help lawyers do that. It's just so hard it changes so quickly.
Yeah, that's kind of what I was thinking of as I was listening to you. It reminded me of how lawyers embraced things like Clio and law practice management software. We had a lawyer a while back that was a solo, and we insured him, and he was all by himself. He had no staff, right. But he figured out, as technology evolved, to use a billing program and generate letters to his clients, and all the things. His office was basically, he worked out of his laptop.
Yep.
And he figured out a way to make his solo practice work without any staff, and he did pretty well, I have to say. And so that was an example of someone who embraced the technology as it evolved, and this was many years ago, but this is kind of the same general thing. Use it with caution, in my view anyway. You're the ethics expert, not me, but as hesitant as I am about this kind of thing, I do see some value to it, and I agree with you. You make a great point that it does sort of even the playing field a little bit for solos in particular, who are out there trying to compete and have limited resources, and this may be one way to do it.
I mean, when you think about just engagement agreements, right? Like, when we think about, okay, how did we teach them to take those just paragraphs, different paragraphs, so that you just weren't sending out the same thing again and again, but you could input into your engagement agreement all the different sections that you thought you would need, and so it would be tailored to a particular client. Well, that took a while to catch on, right? And so now it's just, how do we help them? And so, oh, by the way, so I have so many apps on my phone, and some of I've hid them. There's one called Legal Draft, and then there's ILEX, ILEX. And then there's Legal Agreement Clause. So Legal Agreement Clause, and again, the reviews of these aren't great. I think that the one that I used is no longer supported, so I'm not going to give you that one. And there's Quick Far Bar. So again, if you have whether you have a Droid or I should say Android, an Android or an iPhone, just check your app store, because there just seems to be a proliferation of them now. I think it was called Scratch, the one I had.
Scratch?
I think that was it. The first one, does that ring a bell? That very first one that people were walking around with. And this was like even before I started at the bar.
Wow.
So that'd be 10 years ago.
Yeah.
Okay. So there was, I would look at Fuller's article, because I think that was really helpful. But he refers to, Anthony Davis wrote an argument, and I know Anthony Davis from the Association of Professional Responsibility Lawyers. He wrote as the future of law firms in the age of artificial intelligence. And that was quite a while ago. That was in 2020 that he was, doesn't that terrible? Quite a while ago. But he does talk about the 4 traits that you need for a lawyer, the ones we mentioned. So I guess that's the best I can say is, from my perspective, I wouldn't encourage people to stay away from it necessarily, but it is going to take some time to play with it. Just like, when we started using computer-assisted legal research, I just remember doing a battery case once, and I don't know what I put in, but I got all these, it was for a criminal case, and I got these cases that had to deal with real batteries. And I had, no idea how that happened. So, and I thought I was a pretty good researcher, but obviously I wasn't. But that, again, we're talking about 1977 or 78.
Yeah. Yeah, so I think the general takeaway is, check this out, use it with caution. Attorneys are responsible. You can't say, well, it was ChatGPT, it wasn't me, so I'm not responsible for this mistake. That won't work. So, no, this has been great. I don't see any other questions come in. Aviva, thank you so much for your insight. It's always fun to do programs with you.
It's fun to do them with you.
Yeah, well, good.
That, yeah.
Yes, I know. You sure you want to retire? You should stick around a little bit.
Yeah.
No, I'm not convincing. No. Okay. Viewers out there and those of you here, thank you for participating and joining us in our summer seminar this year. We have applied for 3 ethics credits for this morning's program, and that approval will come, I think, shortly. When you submit, or when you go online to submit your credits, or you're submitting the programs you've attended, I think this would come under there are different buttons, and I think live webcast is the one that will where you'll find this program when you do submit your credits to the state. So Aviva, thanks again. Very much appreciated. And thank you all very much for watching and attending the program. Have a great day. Stay cool. Yes. I see it's already at the hour of 11:45, 90 degrees out with a heat index of 103. I just looked it up on my phone. So
mine says 104.
Okay, well, that's even worse. So stay inside, stay cool, hit the pool, whatever it is today, and have a great rest of the week and weekend. Thank you all very much.
Thank you.